In today's lecture, we're going to be looking at Chapter 12 of the text concerning the negotiated justice and the plea of guilty. Most trials end in a plea agreement, either through some sort of plea bargaining process, or the defendant will just basically plead guilty and accept whatever consequences are wrought upon them. The two most common types of plea bargains are charge bargaining, where the defense and the defendant agree with the prosecutor on what actual charges are going to be pled to, and then it is typically up to the judge in the case to issue a sentence based on the parameters of that charge. Now, it's interesting, sometimes individuals can actually plead to a more serious charge to avoid a more serious punishment. Drugs, for instance, drug distribution or intent to sell drugs, when it's the second or third time you're being charged with it, can carry a very serious penalty. So there was an instance where someone actually pled up to trafficking because it was their first trafficking charge, and it would have been a less serious punishment than their third charge for drug sales. So there are some quirks that come up in the system based on the individual specificity of the particular case. The next is can be count bargaining, determining how many counts an individual is going to be charged. If it is a sort of serial type of criminality, whether that's multiple instances of the same crime, or just having a variety of charges that are brought, they will typically have situations where individuals can plead to just a few of the counts and avoid the prosecution for the rest that sort of get rolled up in there. The next is sentence bargaining, where the defense attorney and the prosecution team decide on the charges and also what the sentence is going to be. If the charges are fairly rigid in terms of what the person can and can't be charged with. And finally, it's just a straight up plea, where the person basically doesn't have anything worked out with the prosecutor and falls upon the mercy of the court, saying that they accept the responsibility and they'll accept whatever punishment that the judge decides to hand down. There are a lot of factors that go into the decision to plea. Some of the major ones are the time constraints, the costs, the ease of maintaining the flow of the system, but also the sort of accepting the responsibility on the part of the defendant. That's a big part of the system, and it's one way that people can really sort of help themselves out in a situation if there is a lot of evidence against them. The case is pretty clearly going to result in a conviction. Accepting responsibility can be something that shows remorse, shows a move towards rehabilitation, and trying to help everyone along through the process. Some of the the factors that go into the process. The first is presumption of factual guilt, that the prosecutor has a good idea of what happened in a case based on the evidence that they've collected that the police have presented to them, and also having experience in the system and being familiar with the human nature associated with criminality, seeing these things in the past, maybe even seeing the particular defendant in the past. All those things can play into the prosecutor building this presumption of factual guilt for the individual defendant. Also, trials are very expensive in terms of the state cost, but also in terms of the cost for the defendant. If you don't make little enough money to be afforded a public defender, a private attorney can be very expensive, very time consuming. These processes can drag out. A trial can drag out over years throughout going through the criminal justice system. And there's no guarantee one way or the other what's going to happen at the end of the trial, whether or not you're going to be found guilty or innocent, depending on a lot of the whims of the jury. We'll talk about some of those things in the next chapter. And then we have the idea of what to do with the guilty. If we sentence everyone to prison, the system would be even more overcrowded than it already is. Prison systems in this country are extremely overcrowded. So we have to rely on the plea deals to um, lean more heavily on non institutionalization for punishment for offenders. So probation, community supervision, halfway houses, having really stringent probation. There's a lot of things that we have to rely on to keep the correctional system operating. One of the ways that could be used to address this is changing what types of things we prosecute people for. And uh, right now, uh, November 2020, Oregon has just passed the first statewide measure to decriminalize small quantities of all drugs. So instead of putting someone on probation for having $100 worth of heroin, it's now either a small fine or the person can seek professional medical help for their addiction and avoid any type of criminal prosecution. So by removing who we bring into the system is really the only way to take pressure off of the system that we have in place now. There are different roles for each member of the courtroom work group. Um, the prosecutor has to, sort of seem fair in these instances. They can't be trying to hammer every defendant that comes along. Then defense attorneys in the future aren't going to work with them. They're going to request trials, and that can be a very sort of long process. The dog. I'm surrounded by dogs right now. I don't know if we can. There's one. There's another one by my feet, and there's another one under the table. It's the courtroom dog work group. The prosecutor has to participate in the process because if they get to a situation where no one's going to work with them and make plea deals, then their case backlog is going to get very long. It's also beneficial for the defendant. And talks about the costs associated with this, and then with the defense attorney as well. They want to have it. It would almost be better for them to not plea the case and have a situation where they're billing more hours, but in reality, that's not really effective. You want to have a better reputation as getting cases handled as quickly as possible, and then sort of moving on to the next one for the sake of the client. Also, you would want to have a good working relationship with the prosecutor so that you can potentially get a more beneficial plea for the current case or cases in the future. For the judge, it's the same thing. It's keeping the process going, making sure that the sides are dealing with each other in a fair process, but also just keeping the court system flowing, keeping it working. Because if every defendant requested a trial, then the whole system would grind to a fairly quick halt. So some of the things that really go into the decision of whether or not to make a plea or what charges, what sort of considerations to give the defendant. Number one is the seriousness of the offense. And that's going to be dictated in the legal code as well in terms of what punishments are and aren't permissible in a particular charge. Next is the criminal record of the defendant. That could directly play into what the options are for a plea deal and what sort of sentence the person can receive depending on their previous convictions for similar crimes. But it also can the prosecutor can look at that and say, well, this person has 20 past felonies. I'm not going to give them any slack this time, even regardless of what the felonies are for. That plays into it. And also how likely the prosecutor feels that they are to get a conviction. The police typically do a pretty good job of investigating crimes that are known to them. Prosecutors' offices can do their own investigations on crimes, cases that they think might be going to trial. So a lot of times the evidence against people is very stringent. People leave trails. If you ever want to see how hard it is to be a criminal, you can pull up your Google history, and not necessarily your search history, but without turning off your GPS, Google, you can see day by day where exactly you went on your phone. it's kind of scary. You can see, on this day I drove around this neighborhood, on this day I drove around the city, and you can see day by day. So that information can be subpoenaed from the phone company, and can be used as evidence. Also, some people will put things into their navigation, and they'll navigate to the crime scene, or they'll take an Uber to or from the crime scene. In some instances, criminals can be very smart, but they can also be very stupid. So when you have a lot of evidence against an individual, it can be beneficial again for everyone to go to through the plea bargaining process. Some cases still go to trial. Defendants are just dead set against pleading. Even if they plea, depending on the charges, they might not be able to have much of a reduction. So rolling the dice at trial might seem like a better idea. It's typically not. The only exception, though, is the plea bargaining process is very detrimental to innocent defendants, which there are some that innocent people that get brought before the court system. So those individuals would probably want to seek a trial. There is the idea of a jury trial penalty. The idea in the criminal justice system that if you waste our time, we're going to waste your time. So if you try to have a trial, oftentimes the prosecution will seek a more stiffer punishment. I knew someone that was charged with a DUI, and instead of pleading to the DUI, which he may have received a day in jail and then would have gotten time served because he was arrested and spent a night in jail, he took it to trial. And at trial, the prosecutor was trying to put him in jail for 2 months. And that was one of the things that the jury, in that case, actually really didn't like, was the sort of overzealousness of the prosecutor. There were other issues with the case, and he ended up being acquitted, mainly because the police officer wrote down the wrong street name for the underlying charge of failure to maintain lane, which means that ticket got dropped, which means there was no underlying charge, and it sort of snowballed because of bad procedural issues with the arrest. But there is the idea that if you go to trial, for instance, in a death penalty case, the prosecutor will seek the death penalty, as opposed to accepting a plea deal where the person will get potentially life without parole. It just depends on the specifics of the case, how punitive the prosecutor can be in enforcing the sort of jury trial penalty. So the formal process of pleading to a charge, it's sort of an ever longer document. More little things have to be added and have to be said and dealt with. Has to be given knowingly, voluntarily, intelligently. The defendant has to be the one that has committed the crimes. You have to admit to that. The defendant has to be mentally competent to waive their rights at trial. It's a trial by jury. The right to confront witnesses, to compel witnesses to testify about the facts of the case, testify on their own behalf. To be free from self-incrimination, because you typically have to admit to the crimes that you've committed. You give up the presumption of innocence, and you also give up the right to an appeal if you plead guilty to a charge. More often than not, the judge or the prosecution is going to require an allocution, which is a statement of the facts as they happened and what led to the criminal offense. And the person has to be competent to do all these things. So if there's any issues with that and the mental health of the individual, they will be reviewed before a plea is allowed to be entered. Some other issues associated with the plea deals are the idea of pleading no contest or nolo contendere. That basically means that you are not admitting guilt, but you are accepting punishment. That is typically only used for smaller offenses, and the application of that is being reduced in a lot of areas because the court system likes to see a definitive statement on the crimes being committed and who committed them. There's also the issue of an Alford plea, which is a sort of very, very rare type of plea where the person is allowed to plead guilty, but they're also allowed to legally maintain their innocence and potentially appeal in the future. But they are pleading guilty. So it has the plea has to be accepted by all parties. Even the judge can refuse to accept the plea, and that can kick it back down to the prosecutor and the defense attorney having to renegotiate it or just take it to trial. Also, if the conditions are not upheld of the plea, then they can be withdrawn. on either side, um, just depending on what's happening in a particular case. It's also important to note that um, it's important for the defendant to have competent attorneys at the plea bargaining process because their right to appeal is limited based on uh, admitting guilt in a particular case. And it'd be very rare for a judge to allow a plea to take place, for the prosecutor to negotiate a plea, to then have that overturned by incompetency of the attorney, of the defense attorney. It would take a pretty serious, flagrant misdeed by them for that to happen. So the idea has come up also about abolishing plea deals and taking things to trial. It's just not feasible. The system is set up and processes too many people for everyone to go to trial. We couldn't even, instead paneling the jury would be very extremely problematic, having to do that constantly. And we'll see some of the issues with paneling a jury in the next slide, sorry, the next PowerPoint. But a lot of people try to get out of jury service. There's a lot of things that are built in the system that allow people to excuse themselves from jury service, and it takes a long time to do that, especially relative to how long some of these other aspects of the trial process take. Um, there'd be no way to conduct trials for every person that's charged with an offense in the United States. There's simply too many people coming into the system for that to happen. It'd be like trying to run a fire hose through your kitchen faucet. The kitchen faucet works pretty good as it is because it's not having that massive amount going through it. The kitchen faucet being sort of the trial process. A lot of the other water, is either held back in different aspects of the plumbing, is diverted around the kitchen sink, but you couldn't put a fire hose worth of water through the kitchen sink, which is what it would be equivocal to trying to trying to process every criminal case through the trial, the whole trial process. So we'll look more specifically at the steps of the trial in the next PowerPoint, but this is just sort of to highlight what the actual process of pleading guilty in a case looks like.